Hi everyone, Gene Richards here again, attorney from the Williams Law Group, back on the Navigating DCP&P podcast, the podcast where we break down complex issues involving the division of child protection and permanency. We discuss oftentimes the keyword permanency, as it is part of DCP&P's name. But what does the court or DCP&P do when permanency isn't clear? Before I begin, I want to remind you all listening out there that any information that I share on this podcast does not create an attorney-client relationship, but we do welcome any person involved with DCP&P to contact our office for a confidential consultation with our team. So as a quick reminder and rundown of different permanency options here in New Jersey, there are the options of reunification with the parent or the parents. There is TPR to adoption. There is kinship legal guardianship or KLG. You have independent living, and you also have other planned permanent living arrangements or arrangements. And so what are these plans? Well, specifically today, we're going to talk about the last plan, really the least popular or common plan, that being other planned permanent living arrangements. So what is that? Well, it's a court-approved permanency plan used only when reunification, adoption, KLG, or independent living are not possible. This is sort of the last resort. Now, like in any other case or permanency plan, the child's best interest still guides that decision and every decision in that process. The judge, the court, must find that the other permanency options aren't realistic. Reunification can't happen. No one's available to adopt. There is no person available to have the KLG in place, or the child perhaps isn't old enough or able to live independently. So how do we get here? What happens? Well, first of all, this arrangement, it's more common, more so among those who need long-term residential treatment or specialized care due to a disability, right? Because reunification, the parents are willing, able, fit to have the child return to their care. Adoption, someone's willing, able, fit to adopt that child. KLG, a relative, a close friend, somebody is willing to have that child in their care. Independent living, the child is of age, usually over 16, and can learn tasks and skills to allow themselves to live independently. And so in these situations, the child perhaps isn't in a position to live independently, and there is nobody willing or able to adopt. And the parents can't or aren't able to have this child placed back in their care. So what happens under this other planned permanent living arrangement? Well, as I mentioned previously, it may be a child that has a disability, and they must continue being in some sort of facility, residential, or specialized care. And in these situations, technically, based on it being a permanency plan, nobody is willing or able or available to adopt. Now, the issue here is that, as in pretty much every other situation with the court and with DCP&P, there are flaws to this process. And one of the bigger flaws is, how does the child really feel? This is permanency, but there's still instability. Is it really permanency, having a child in treatment where the child could be placed somewhere else in a different facility down the road based on recommendations? So the child may feel very uncertain about their future. This child isn't going to have an adopted parent. This child isn't going to be going back home. Parents aren't able to rectify the issues to allow this child to come back home. And so there needs to be a balance of this oversight, having a child where this child needs to be in a facility or in care, if that's even accurate, but also providing stability. And really, why can't a child be in a residential treatment or long-term care, specialized care, and still be reunified, still be adopted? These options, these permanency plans really don't have to be different in that sense, right? Why can't a child be placed back in a parent's care if that parent is fit, and have that parent ensure the child is in long-term care, specialized care? The biggest issue I see, because I've had a case just like this, where division, they were granted guardianship, the parental rights were terminated. It wasn't my client, but the parental rights were terminated. So the goal was to be adopted, but then things change. This child has a certain disability. This child needs to be in long-term care at a facility, which is where this child remains to be. But in this case, there have been individuals, currently an individual, who are saying, wait, but I'm willing to adopt this child. This child should have the right to have somebody love and care and have the parental role over her. This child should not have to be in division, custody, or guardianship under this almost phony permanency plan. This child should have the ability to be part of a family again. And the issue is that in these situations with this other planned permanent living arrangement, who's going to oversee the child? Who's going to be in charge of making decisions for this child? Well, in this case, it's still DCP&P. The termination trial, again, I wasn't part of this process. I've been involved the last 8-9 months with an individual who's trying to adopt this child. But DCP&P had the TPR trial through the court. It happened several years ago. And since that time, this child in DCP&P's mind has permanency. This child is being overseen by the state. This child getting appropriate care at a facility. This child is in good hands. This is what DCP&P is or might be saying. But on the other hand, we have an individual who knows this child, isn't family, but knows this child, has a connection with this child in the past, is saying, I don't care if she's in a facility or any, I want to be a parent, an adopted parent of this child. I want to provide permanency and have this child be part of a family. Again, not part of DCP&P's family or that entity, but part of an actual family. And unfortunately, DCP&P is basically saying at this juncture that, well, this child is stable, there's permanency, this child is in a facility and she's doing well. Well, for all we know, perhaps this child doesn't actually have to be there. Perhaps there are other available options or places to go or more short term, or perhaps when she's discharged, knowing she has a place to go, a home to go to, will prevent other residential or long-term placement. And so unfortunately, in these situations where a child is disabled or needs long-term care for whatever reason in a residential facility or specialized care, and this is where this child ends up being post-TPR trial. Even though there is currently an individual, and there have been other people in the past who they've dropped out for different reasons, but even though there's a person who is saying, I want to adopt this child, I want to have this child have real permanency, have real stability, because at least in my opinion, this idea of this other planned permanent living arrangement, this child being in a facility while under DCP&P's watch and care, to me, that's not permanency. To me, that's not stability. This child is still sort of in limbo, and this child could and should still be adopted if somebody is willing, able, and fit to do so. The other issue with this is that a lot of times the state just wants to have the days and the years tick away because this child still on the younger side, I believe 14 or 15 years old. So she's not quite that close to being 18 or being an adult. But in these situations, as time ticks on, it's like this child needs to be part of the system until she ages out. And unfortunately, because DCP&P has guardianship, has custody of this child, DCP&P has a lot of say, a lot of weight in terms of somebody adopting this child. They can rule people out or say, we don't think it's in this child's best interest to be placed or be adopted by you. And so there are so many different ways and different hurdles that a person has to overcome to allow this child to what I define to be as true permanency. And so it's a very difficult case, and these cases are difficult in general, but there are ways and avenues that we as an office can create to make this system better for the litigant. First, we file an appeal with the OAL. We file an application with Superior Court. And so there are different ways to have these issues come to light. There are ways to try and fight back a flawed and broken system. Because although we're fighting on behalf of this individual who wants to adopt this child, really what we do as attorneys is fighting for what's best for a child, what's in their best interest. The goal of family court is supposed to be always what's in the best interest of the child. Now, of course, we in these cases weigh the rights of a parent, right? The constitutional right that we have as parents with a child's best interest, but ultimately, basis for any decision is and should be the best interests of the child. And is it best for a child to, although getting treatment that he or she may need, which is also debatable, right, while under the care and supervision and custody and guardianship of the division, the state, is that really in a child's best interest? Now, sure, it could be, but in cases like this where a parent, not a parent, but an individual who wants to become an adopted parent, has had their home license, has gone through the process, has a connection with a child, is willing, able, and fit to adopt, why wouldn't that be a better outcome? And so, yes, we're fighting for that person to have their right to adopt this child, but ultimately we're fighting for what's best for a child, and that's to be loved and cared for by somebody, be part of a family and a home, not be in the system for 3 or 4 more years. And sure, she's getting care as far as we know, but she's still just part of the system. She's still part of the state. There's no connection, no home, no family. And so the issue with that permanency plan is that I would argue it's not permanency at all. Now, look, if there's nobody, which is sad, it's a sad reality, no one is willing or able to adopt the child, and the child needs long-term care, then that's great. The state is jumping in to provide that care and that permanency, so to speak, in those situations. But it's not a one-fit-all situation. And DCP&P trying to rule folks out and to determine or to try and keep this child in the system, that's not permanency when someone else is willing and able to adopt a child and provide that stability and permanency. And so it's a long-term fight in terms of these situations because this child, permanency has happened in the eyes of the court. But again, this isn't permanency when somebody is willing and able and fit to adopt and provide real permanency. So I do want to just highlight that and that flaw in the system. And as always, I want to thank everyone who is listening and tuning into this podcast and this episode. Permanency is a big deal, and children have the right to have that permanency. But as we discussed today, perhaps permanency isn't always permanent. And even if a plan is accepted and proposed by the division, it doesn't mean it's not subject to be changed. If the facts and situations and different individuals come to the table to provide permanency, that needs to be addressed. That needs to be considered appropriately. As always, I want to call and everyone here who is listening to the action of subscribing to this podcast, to our channel, and sharing the videos, sharing the post. And so on next week's episode, again, trying to inform those who don't know and are part of DCP&P case, we're going to discuss safety plans. What are safety plans? What do parents need to know about safety plans? How do safety plans affect a case and a family and kids? So again, we'll discuss that next week. Look forward to talking to you about that at that time. And until then, have a great week.